I was 7 minutes from home when the lights came on behind me. Blue and red, no siren at first. Just the lights cycling in my rearview mirror on a Tuesday afternoon in the middle of October. I had been driving that same stretch of Hartwell Road for 11 years. I knew every pothole, every traffic rhythm, every intersection where the light cycled short in the afternoon. I was doing 32 in a 35. My hands were at 10 and 2. I had just come from my office at the university where I worked as an administrative coordinator in the registrar's office, and I was wearing my work lanyard around my neck because I always forgot to take it off until I walked through my front door. I pulled over immediately. No hesitation, no delay. I put the car in park, turned off the engine, rolled down the driver's side window, and placed both hands on the steering wheel. I had been stopped twice before in my life, both times for minor equipment violations, and both times I had walked away with a verbal warning. I had no reason to believe this was anything different. The first patrol car stopped behind me. Then a second one pulled up alongside the first. Then a third one angled across the oncoming lane about 40 yards ahead of me, blocking any forward movement. I understood immediately that this was not a routine stop. Through my rearview mirror I could see the officer from the first car speaking into his shoulder radio before he opened his door. When he stepped out, he did not approach my vehicle. He moved to the rear of his car and crouched behind the engine block. I heard the second officer exit his vehicle as well. Then I heard a voice through a loudspeaker, clear and flat, telling me to put my hands outside the window where they could be seen. I pushed both arms out through the driver's side window, palms open, fingers spread. The voice on the loudspeaker told me to open the door from the outside handle and step out slowly. I did exactly what they said. Every movement I made was deliberate and slow. I kept my eyes forward, my arms away from my body, and I stepped out of the vehicle and stood with my back to the patrol cars. Then I heard them running toward me, and before I could process what was happening, my face was against the hood of my own car, and my wrists were being cuffed behind my back. Not roughly, professionally, with the precision of people who had done this many times. That distinction mattered to me in that moment, though I could not have explained why. One of the officers told me I was being detained in connection with a reported vehicle theft. He read me the year, make, model, and license plate of the car I was standing beside. It matched exactly. I said, "I own that car." He said, "We'll sort it out at the station." They walked me to the back of the first patrol car, put a hand on top of my head to guide me into the seat, and closed the door. Through the window I watched 2 more officers approach my vehicle and begin looking through it with flashlights, even though it was 2 in the afternoon and full sunlight. Another officer was photographing my license plates. I sat in the back of that patrol car for 19 minutes before anyone spoke to me again. During those 19 minutes I tried to organize my thoughts. I was not panicking. I was confused, but confusion and panic are different states, and I had trained myself over years of difficult circumstances to stay inside confusion rather than let it bleed into panic. Panic destroys your ability to remember things accurately. Confusion, if you sit with it carefully, starts to show you its edges. The edge I kept returning to was the vehicle itself. I had purchased that car 14 months earlier. A dark blue 4-door sedan, 4 years old at the time of purchase, bought from a private seller through a transaction that had been documented, notarized, and registered with the DMV without complication. I had the title, I had insurance. I had registration. All 3 documents were in the glove compartment of the car that was currently being searched 40 feet in front of me. A vehicle theft report requires a complainant. Someone had to have made the report. Someone who knew the make, model, and plate number of my specific vehicle. That was not a random call, that was a directed report. I went through the people in my life who had ever been inside that car or had seen that car parked outside my home. The list was not long. My neighbor, 2 colleagues who I had driven to a conference, my mother, and my brother Marcus. I stayed with that list for the remainder of the 19 minutes, and by the time the door opened, and a uniformed officer leaned in and asked me to come inside the station with him, I had already begun to understand what had happened, though I did not yet have the proof. The station was a mid-sized municipal facility, clean and fluorescent lit, with the particular stillness of a place where serious things happen routinely. I was uncuffed in a processing area and asked to sit in a chair beside a metal desk where a detective introduced himself. He was a compact man in his mid-50s, with reading glasses hanging from the collar of his shirt, and the manner of someone who had long since stopped being surprised by anything. He told me his name was Detective Halbrook, and that he was going to ask me some questions, and that I was not under arrest but that I was being detained for questioning. He asked me to confirm my name, date of birth, and address. I gave him all three. He typed them into a computer and studied the screen for a moment without speaking. Then he turned the screen slightly toward me. On it was a theft report filed at 8:47 that morning. The report described a vehicle with my exact plate number and said it had been taken from a residential address on Callaway Street without the owner's consent. The name on the report as the complainant was Marcus Devin Callaway, my brother's name. My brother, who did not own that car and never had. My brother, who lived on Callaway Street, which was our mother's address, where I had not lived in over a decade. I looked at the screen for a long time without speaking. Detective Halbrook asked me how I knew Marcus Devin Callaway. I said, "He is my brother." Halbrook wrote something on the notepad in front of him, and then looked up at me with an expression that told me he had already started revising his initial read of the situation. I asked him if I could see the full report. He printed it and slid it across the desk. I read it carefully. The report stated that the vehicle had been loaned to a family member who had not returned it, and had therefore been reported stolen. The family member in the report was not named. The complainant had described the borrowing arrangement as verbal and informal, with not written documentation. I set the report down on the desk. I said, "I have the title, the registration, and the insurance in the glove compartment of that car. My name is on all three. I have never loaned that car to Marcus Callaway or anyone else. I purchased it 14 months ago and I have documentation of that purchase." Halbrook looked at me for a moment and then asked one of the officers near the desk to retrieve the documents from the glove compartment of my vehicle. While we waited, he asked me to walk him through the purchase. I did. I described the seller, the transaction, the notarization, the registration, the timeline. I gave him the name of the insurance company and the policy number from memory, because I had memorized it when I set up automatic payments. I gave him the name of the DMV location where I had registered the title. The officer returned with my documents. Halbrook examined them one by one. Title, registration, insurance card, all three in my name. The purchase date on the title was 14 months prior, which was 11 months before Marcus Callaway had filed the theft report that morning. Halbrook looked at the title for a long time. Then he looked at the theft report. Then he looked at me. He asked if there had been any prior arrangement or agreement between me and my brother regarding the vehicle that might have created any ambiguity about ownership. I said none. He asked if Marcus Callaway had ever had a key to that vehicle. I said no. He asked if Marcus Callaway had ever been inside that vehicle. I said no. Once approximately 9 months ago. I drove him from my mother's house to a pharmacy and back. He was never alone with the vehicle, and I have never given him a key. Halbrook closed the folder in front of him and pulled off his reading glasses. He rubbed the bridge of his nose once and then looked directly at me. He said, "I'm going to need to speak with the complainant." He told me I was free to wait in the station or to leave, and that no charges would be filed against me at this time. He said the vehicle was being released back to me immediately. He gave me a document number and said if I needed to reference this incident I could do so with that number. I did not leave immediately. I asked Halbrook if I could ask him a direct question. He said yes. I asked whether filing a knowingly false police report was a criminal offense in this jurisdiction. He looked at me with an expression that was neither confirming nor denying but that told me everything I needed to know. He said, "You'd want to speak with an attorney about that." I thanked him, collected my documents, and walked back out to my car. The 3 patrol cars were gone. My car sat at the curb exactly where I had left it, engine off, doors closed. Someone had placed my keys on top of the driver's side tire. I picked them up, sat in the driver's seat, and did not start the engine immediately. I sat there for approximately 4 minutes thinking about Marcus. Marcus Devin Callaway was my younger brother by 3 years. We have not been close as adults, which was a polite way of describing a relationship that had been, for the better part of 15 years, defined by a series of financial intrusions, broken agreements, and what I had come to recognize as a pattern of deliberate exploitation of family obligation as a mechanism for personal benefit. He had borrowed money from me 7 times in the past decade. 5 of those loans had been repaid, partially after extended periods of delay and negotiation. 2 of them had never been repaid at all, totaling a combined amount of $4,600. I had stopped lending him money 3 years prior, after the second unrepaid loan, and I had communicated that decision to him plainly and without hostility. What had followed that communication was a gradual withdrawal from contact on his part, which I had interpreted as resentment but had not pursued. I did not reach out to force reconciliation. I did not call our mother to mediate. I allowed the distance to exist because the alternative was to continually renegotiate a relationship in which I was always the one making concessions. 6 weeks before the traffic stop, I had received a text message from Marcus that I had not responded to. The message asked if I would be willing to loan him my car for a few days, because his had been repossessed. I read the message and I did not reply. Not out of cruelty, but because I knew from experience that lending him anything created a new obligation that I would eventually have to enforce at significant personal cost. I had not responded to the message. This, I would later understand, was the specific act that had preceded the morning's report. I drove home. I did not call Marcus. I did not call our mother. I did not call anyone. I went inside, changed out of my work clothes, made coffee, and sat at my kitchen table with a legal pad and a pen. I wrote down everything I remembered in the order it had happened, with approximate times noted beside each entry. I wrote down the name of the detective, the document number he had given me, the time I had been released, the content of the theft report as I had read it, and Marcus's text message from 6 weeks prior, which I then retrieved from my phone and photographed. Then I started making calls. The first call was to my insurance company. I reported that my vehicle had been involved in a false theft claim, and I asked them to note the incident on my policy file and flag it in case any subsequent claims were made, referencing that report number. The representative asked for details, I provided them, and she told me that a notation had been placed on my account. I asked her to send me written confirmation of that notation. She said she would send it within 48 hours. The second call was to the DMV's title verification line. I confirmed that the title on record for my vehicle showed me as the sole owner, with no liens, no disputes, and no alternate claimants. The representative confirmed all of that. I asked her to email me a title verification summary. She processed the request. The third call was to a civil attorney I had spoken with, once, 2 years prior, during an unrelated matter involving a contractor dispute. He remembered me. I gave him a compressed version of the afternoon's events. He listened without interrupting. When I finished, he said that what I was describing, specifically a knowing false report to law enforcement, identifying a specific individual as a vehicle thief, when the complainant had no legitimate ownership interest and no documented agreement with the individual, constituted filing a false police report, which was a misdemeanor in our state. He also said that depending on intent, it could potentially support a civil claim for malicious prosecution or abuse of process if the matter proceeded further. He asked if I wanted to schedule a consultation. I said I wanted to wait one day and see how the police investigation developed, and then I would call him back. He said that was reasonable. He also said I should start collecting everything in writing and avoid all direct communication with Marcus until I had a clearer picture of how this was going to move. I thanked him and ended the call. It was 5:43 in the afternoon. 3 hours had passed since the traffic stop. I had a legal pad full of timestamp notes, a photograph of a text message, 2 pieces of written confirmation in transit from my insurance company and the DMV, a detective's name and case number, and the advice of an attorney. I also had a decision to make about my mother. My mother, Elaine Calloway, was 67 years old, and lived alone on Calloway Street in the house Marcus had given his address as on the police report. She had health problems that required regular medication management, and I had been the primary family member managing her prescriptions, driving her to appointments, and handling her household needs for the past 4 years. Marcus contributed nothing to that effort. He had not contributed anything to it consistently in at least 6 years. My mother was not my enemy. She was also not a neutral party when it came to Marcus. She had a long pattern of believing what Marcus told her, extending him the benefit of the doubt in situations where the evidence did not support that extension, and framing his failures as external circumstances rather than choices. I understood why. I did not resent her for it. But I knew that if I called her that evening and told her what had happened, Marcus would know about it within the hour, and whatever version of events he had already prepared would be communicated to her before I could establish any factual record. I decided not to call her that night. Instead, I sent her a short text that said I had had a complicated day and would call her tomorrow morning. That was true and gave nothing away. I went to bed early, not because I was calm, but because I had learned a long time ago that rest is a tactical resource, and that sleep deprivation is one of the mechanisms by which people make irreversible mistakes in situations that require precision. At 6:47 the next morning, before I called my mother, my phone rang. The number was Marcus's. I let it ring. He called twice. I did not answer. The second call went to voicemail and he left a message. I played the message once and then replayed it while writing down the exact words. The message said approximately, "Hey, it's Marcus. I heard there was some kind of mix-up with the police yesterday. I don't know what they told you, but I was just trying to protect the car since I didn't know where it was. Call me back, let's just talk about this. It doesn't have to be a big deal. I noted the time of the message, the wording, and the phrase trying to protect the car, which implied a belief on his part that the car was his to protect. I saved the voicemail and emailed the transcript to myself with the timestamp. I called my mother at 8 in the morning. She answered on the second ring, and told me Marcus had called her the previous evening, saying that there had been a misunderstanding with police and my car. She said he had told her he had panicked when he couldn't reach me, and had made a report thinking the car might have been taken by someone who had borrowed it from me. I listened to all of that without interrupting. Then I said, "Mom, I need you to understand exactly what happened." I told her, not with emotion, not with accusation, but with sequence. I was pulled over at gunpoint. My car was flagged as stolen. The report was filed by Marcus. His report described a verbal lending arrangement that never existed. I had documentation proving sole ownership of the vehicle predating his report by over a year. I was detained for questioning and released when I presented my documentation. A detective was now investigating the report's validity. There was a long silence. My mother said, "He said it was a misunderstanding." I said, "Mom, there was no misunderstanding. A misunderstanding is when someone makes an honest mistake based on incomplete information." Marcus filed a report stating that a vehicle belonging to him had been taken without his consent. He does not own that vehicle, and he has never owned that vehicle. That is not a misunderstanding. That is a false statement given to law enforcement. Another silence. She asked if the police were going to arrest Marcus. I said I didn't know what the police were going to do. I said that was their process to manage. I told her I was documenting everything for my own protection. She said she hoped it wouldn't go too far. I told her I was sorry that she was in the middle of it, but that I needed her to understand that I had not created this situation. She said she knew that. I believed she did know that at some level, even if she could not say it cleanly. That was enough for the moment. After I hung up, I sat with the conversation for a moment and then moved forward. By 9 in the morning, I had received the email confirmation from my insurance company. The notation on my account had been recorded the previous evening, timestamped at 6:12 p.m., referencing the theft report number and noting that the policyholder had identified the report as fraudulent. The email was from a named representative and included a case reference number for the insurance company's internal file. By 9:45, the DMV verification summary arrived. It confirmed registered owner, vehicle identification number, title issue date, and the absence of any competing ownership claims or liens. I printed both documents, placed them in a folder with the legal pad notes and the attorney's contact information, and drove to the police station. I asked to speak with Detective Halbrook. He came out to the lobby after about 6 minutes. He did not seem surprised to see me. I said I had additional documentation I wanted to add to the case file, and I wanted to make a formal statement. He led me back to the same desk from the day before. Over the next 40 minutes I provided him with everything. The text message from Marcus 6 weeks prior, in which he explicitly requested to borrow the car and identified the reason as a vehicle repossession. The voicemail from that morning in which Marcus described the report as an attempt to protect the car, the insurance confirmation, the DMD verification, the purchase documentation I had already provided, and my own written timeline from the previous evening which I had organized chronologically with every relevant timestamp. Halbrook read through everything methodically. He made copies of each document. He asked me several clarifying questions, primarily about the text message and the voicemail, confirming dates, confirming the phone number belonged to Marcus, confirming that Marcus had never at any point been added to any insurance or registration document related to the vehicle. I answered each question precisely. At the end of the session, Halbrook told me that an interview with Marcus Calloway had been scheduled for that afternoon. He said the investigation was ongoing and that I would be notified of any developments. He asked me to confirm that I was not planning to contact Marcus directly. I told him I was not. He nodded and wrote something in his notepad. As I stood to leave, he said something that I have thought about many times since. He said, "The record you've built on this in 24 hours is significantly better than most people manage in 2 weeks." I said, "I've been in situations before where I had to rely on records. I've learned to build them fast." He looked at me for a moment with what I would describe as professional respect, the kind that passes between people who understand something about process and documentation, and he said nothing further. I left the station and went to work. The day at the office was quiet. I did my work, I answered emails, I assisted 2 students who needed transcript verification, I ate lunch at my desk. Nobody there knew what had happened because I had not told anyone. I did not believe my professional environment needed to be involved in my personal circumstances, and more practically, the situation was not resolved yet, and I had no interest in telling an incomplete story. At 3:48 in the afternoon, my phone rang. The number was Detective Halbrook's direct line, which he had written on a card and given me that morning. I stepped outside the building to take the call. He told me that he had conducted the interview with Marcus Calloway at 2 in the afternoon, and that the interview had revealed a series of inconsistencies in Marcus's account that were significant enough to affect the status of the theft report. He told me that the report was being reclassified and that Marcus had been informed that providing false information to law enforcement was a criminal offense and that the department was reviewing the matter for potential prosecution. He paused there and let me respond if I wanted to. I said, "What does reclassified mean exactly in terms of my record?" He said that my name would appear in the incident as the registered vehicle owner who had been incorrectly flagged, not as a suspect. He said the report would reflect that the initial theft claim was unsubstantiated. He said that if I wanted a copy of the reclassified incident report for my personal records, I could request it through the records office and it would be available within 3 to 5 business days. I asked if there was anything further he needed from me. He said not at this time. I thanked him and ended the call. I stood outside the building for a moment. It was a cool afternoon, the kind where the light is flat and the air smells faintly of fallen leaves. I looked at my phone. I looked at the screen showing Halbrook's name in the recently dialed list. Then I put the phone in my pocket and went back inside to finish my workday. I called the attorney that evening. I gave him the update. I told him the report had been reclassified, that Marcus had been interviewed, and the inconsistencies in his account had been identified, and that the department was reviewing potential prosecution. The attorney was quiet for a moment and then said that the reclassification, combined with the documentation I had provided, put me in a strong position if I wanted to pursue civil action. I asked him to explain what that would look like practically. He said that filing a knowingly false police report that resulted in a detained traffic stop, a weapons-drawing response, and the requirement to appear at a police station and spend hours establishing innocence constituted, at minimum, the basis for a civil claim. He said that the voicemail, in which Marcus described attempting to protect a car that did not belong to him as justification for the report, was particularly significant because it demonstrated awareness of the act rather than innocent mistake. I asked him to explain the distinction. He said that in civil claims of this nature, the difference between a mistake and an intentional act matters enormously to the outcome. He said that the text message from 6 weeks prior was also significant because it documented that Marcus had requested use of the vehicle, then implicitly refused by non-response, and then filed the report. That sequence, he said, suggested the report was not an act of concern or confusion, but an act of retaliation. The word retaliation sat in the air between us on the phone. I said, "How long would a civil case take?" He said that depended on whether Marcus contested it. He said that if I filed and Marcus chose not to fight it, it could resolve relatively quickly. He said that if Marcus contested it, we were looking at a longer process. I said I would think about it and call him back within a few days. After I hung up, I went back to my kitchen table with the legal pad. I drew a line down the center of the page. On the left, I wrote the costs of pursuing civil action: time, energy, money, familial disruption, the impact on my mother. On the right, I wrote the costs of not pursuing it. No formal accountability, the implicit message that what Marcus had done carried no consequences, and the practical risk that without a formal civil record, the criminal reclassification alone might not be enough to prevent a similar act in the future. I stared at both columns for a long time. The right column was shorter but heavier. I called the attorney the next morning and told him I wanted to proceed. He said he would begin drafting the civil complaint and that he would have a draft for me to review within 5 days. He asked me to send him everything I had, all the documents, the photos of the texts, the audio of the voicemail, the timeline notes, the insurance and DMV confirmations, and the incident case number from the police. I sent everything to him in a single organized email within the hour. Over the next 5 days, while the attorney worked on the draft, I returned to my routine. I drove my car to work and back without incident. I continued managing my mother's prescriptions and drove her to a medical appointment on Thursday. She did not bring up Marcus, and I did not bring up Marcus. The appointment went smoothly. I dropped her home, checked that her medications were organized for the week, and left. On Thursday evening, as I was leaving her house, Marcus's car was parked on the street. He had not been inside during my visit, Or, if he had stayed in another part of the house. I noted the car, noted the time, and continued to my own vehicle. That was the first time I had seen any physical evidence of him since the traffic stop. The attorney sent me the draft complaint on Friday afternoon. I read it twice, carefully. It named Marcus Dedon Calloway as defendant, described the filing of the false police report, the consequent traffic stop, the drawn weapons, the detention, the hours spent at the police station, the emotional and reputational harm of being detained on suspicion of stealing a vehicle I owned, and the pattern of contact suggesting the report was retaliatory in nature rather than a genuine attempt to protect property. The complaint cited the reclassification of the police report, the voicemail, and the text message as primary supporting evidence. The attorney had included a section detailing the specific police response, noting the 3-vehicle deployment and drawn weapons, and characterizing the level of law enforcement response to the false report as evidence of the severity of the harm caused to me, as a false report of an elevated nature had created conditions in which I was at elevated physical risk during the detention. I read that section 3 times. I had not fully thought through that angle before. The guns, the 3 patrol cars, the officer positioned behind the engine block of his vehicle. These were not incidental details. These were the specific danger generated by a false report characterizing me as someone who had stolen a vehicle and was actively evading with it. A false report shapes the response to it. The response I have received was shaped by what Marcus had described. I called the attorney and told him I had one change to the complaint. I wanted to add a line explicitly noting that the responding officers had drawn their firearms and that I had been ordered to exit the vehicle with my hands visible before being handcuffed. He said he had included a reference to drawn weapons, but could be more specific. He revised the complaint and sent a second draft within the hour. I approved it. He filed it the following Monday. The filing went through the civil division of the county court without complication. Marcus was served notice within 2 weeks. I know this because the attorney called me to confirm it the same day the service was completed. He also told me that within 24 hours of receiving service, Marcus had called the attorney's office directly and asked to speak with him. The attorney said he had informed Marcus that any communication regarding the matter would need to go through formal channels. Marcus had then called my phone. I did not answer. He called twice more that day. I did not answer either time. He did not leave a voicemail on any of the 3 calls. My mother called me that evening. She was upset, not with me, but in the way she always thought upset when family conflict acquired formal dimensions. She was asked me if there was any way to handle this without going to court. I told her I understood why she was asking, and that I was sorry she was experiencing distress, but that what Marcus had done had exposed me to physical danger and had required me to spend hours establishing my own innocence, and that I did not believe he should face no formal consequence for that. She was quiet. I said, "Mom, I was detained at gunpoint because of a lie he told. I'm not doing this to punish Marcus. I'm doing this because there has to be a record." She said she understood. I do not know if she fully did, but she did not push further. Over the following 3 weeks the civil case moved through its preliminary stages. Marcus retained an attorney, a fact I was informed of when the attorney of record filed an appearance in the case. I took this as a sign that Marcus understood the severity of the situation, even if he was not prepared to acknowledge it directly. The opposing attorney filed an initial response to the complaint that attempted to characterize the report as a good faith effort to locate a vehicle that Marcus had reason to believe was missing or misused. The response did not deny that the report had been filed. It did not deny that Marcus had filed it. It attempted to reframe the report as arising from genuine concern rather than retaliation. The text message from 6 weeks prior made that argument very difficult. My attorney filed a brief response pointing out that 6 weeks before the report, Marcus had explicitly stated in a text message that he wanted to borrow the car because his had been repossessed, and that my non-response to that message was the only preceding communication between us about the vehicle. He argued that the sequence request, refusal by silence, and then theft report constituted a pattern inconsistent with good faith concern and consistent with retaliatory intent. He also attached the voicemail transcript in which Marcus described trying to protect the car, noting that one cannot protect property one does not own and has never owned, and that the phrasing demonstrated awareness that the vehicle was in my possession and not missing. A settlement conference was scheduled for 5 weeks later. In the weeks between the filing and the settlement conference, the criminal side of the matter moved in parallel. I received word through my attorney who had made an inquiry with the detective's office that the district attorney's office was reviewing the false report for potential misdemeanor prosecution. The review was ongoing and no formal charge had been filed yet, that the review itself had been initiated. I noted this in my records but did not adjust my expectations. The criminal process would move on its own timeline. My direct interest was in the civil matter, where I had more agency over the outcome. The settlement conference took place on a Wednesday morning in a conference room at the courthouse. I arrived 8 minutes early. I wore a dark suit and no lanyard. I brought the folder of documents, the same folder I had built over the first 24 hours, plus the subsequent additions. My attorney was already there when I arrived. Marcus came in 7 minutes after the scheduled start time. He was with his attorney, and he looked different from how I remembered him. Thinner, and carrying a particular expression I recognized from childhood as the expression he wore when he knew he had done something wrong and was hoping no one would articulate it clearly. The conference was conducted by a mediator appointed by the court. She was a methodical woman who moved through the agenda with minimal ceremony. She outlined the complaint, the defendant's response, and the purpose of the conference, which was to explore whether a resolution could be reached without proceeding to trial. Marcus's attorney spoke first. He reiterated the good faith narrative. He acknowledged that the report had created inconvenience and distress for me. He suggested that a formal apology and a nominal compensatory payment might be appropriate to resolve the matter. My attorney said that the documented record did not support the good faith characterization, and that the harm created was not a matter of inconvenience. He described the traffic stop in specific terms: 3 patrol cars, officers in defensive positions, drawing firearms, a handcuffed detained individual who had committed no offense and owned the vehicle outright. He said this was not an inconvenience. He said this was a situation in which a false police report had placed his client at material risk of serious harm, and that the record of that report, the voicemail and the text message established a pattern that made nominal compensation inadequate. The mediator listened to both sides and then asked Marcus directly if he understood that the text message from 6 weeks prior was part of the court record. There was a pause. Marcus's attorney whispered something to him. Marcus said yes. The mediator asked him to confirm, for the record, that the text message on his phone had been sent to my number. He said yes. The mediator asked him to confirm that he had not received a response to that message. There was a longer pause. He said that was correct. The mediator then asked his attorney to explain, given that established sequence, how the theft report could be characterized as arising from good faith concern about the vehicle, rather than from the preceding context of a denied request. The attorney's answer was careful but insufficient. He said that Marcus had other reasons to believe the vehicle might be at risk. When the mediator asked what those reasons were, and whether they were documented, there was no satisfactory answer. The conference continued for another hour. By the end of it, Marcus's attorney had indicated willingness to discuss settlement terms that went beyond a nominal amount. My attorney proposed specific figures. Marcus's attorney said he needed to consult with his client. The mediator scheduled a follow-up session for the following week. I said nothing during most of the conference. That was deliberate. I had come to provide presence and documentation, not argument. My attorney was there to argue. The documents were there to speak. I watched Marcus across the table during the portions of the conference where he was being addressed directly, and I made no effort to communicate anything with my expression. He did not look at me directly for the first half of the session. Near the end, when the mediator had asked him the second question about the text message, and he had given his answer, he glanced at me briefly. I held his gaze without changing my expression. He looked away. That evening I drove past Hartwell Road, the stretch of road where the traffic stop had happened. I did not stop. I noted the spot, the particular curve in the road before the intersection, and then continued home. The follow-up conference took place 1 week later. I will condense what happened because the mechanics of settlement negotiation are not the most instructive part of what this experience was ultimately about. Marcus's attorney arrived with a revised posture. They were no longer advancing the good faith narrative as a contested point. They acknowledged that the sequence of events, the text message, the non-response, and the subsequent report, had created circumstances that were difficult to characterize as anything other than ill-conceived. Their focus had shifted to minimizing the settlement amount and avoiding a trial. My attorney held the line on what I had authorized: a written, formal acknowledgement that the theft report contained materially false information, a monetary settlement to cover my legal fees, the documented hours I had spent at the police station and in preparation of the case, and compensation for the specific harm of being subjected to a weapons-drawn traffic stop as a direct result of the false report, and a permanent record in the civil court of the settlement and its terms. Marcus agreed to all three. I signed the settlement agreement in the same conference room 8 days later. Marcus signed separately. I did not see him sign. I did not need to. The mediator confirmed both signatures and filed the agreement with the court. On the drive home, I stopped at a coffee shop I had been going to for years and ordered a coffee and sat by the window. I had my phone and my folder. I opened the folder and looked at the first document I had created, the handwritten timeline from the evening of the traffic stop. The ink on the first line, which noted the time of the initial lights in my rearview mirror and my exact speed, had dried to a particular shade of faded blue-black that I associated with the legal pads I had been using for years. I thought about the day Marcus had sat in my passenger seat on the way to the pharmacy, how ordinary it had been, how little either of us had said, how I had thought, driving back, that the distance between us was a quiet kind of peace, a mutually accepted conclusion to something that had never quite worked. I had not imagined then that the distance would eventually require police involvement to maintain. I also thought about the detective's observation about my record building, that it was better than what most people managed. I thought about why that was. It was not because I was unusually disciplined or particularly strategic in nature. It was because I had spent enough years in situations where I had been disadvantaged by not having documentation, that I had eventually decided I would never be in that position again. When someone created a situation that required me to defend myself, the defense would be built on facts, dates, names, and documents. Not on being louder or more emotional, not on appealing to people's sympathy or sense of fairness. On records. Records are not cold. They are not impersonal. They are the accumulated evidence of what actually happened, preserved against the revisionist pressure that comes from people who benefit from ambiguity. Every document in that folder was a refusal to let the truth be renegotiated. The criminal matter resolved 3 months later. The district attorney's office filed a single misdemeanor count of filing a false police report against Marcus Devon Calloway. He entered a no-contest plea. He received a fine, probation, and the conviction was entered on his record. I was not present for the hearing. I had been informed of the outcome by my attorney and by a separate notification from the court. I did not feel satisfaction at the outcome in the way that I might have when I was younger, when I still believed that emotional relief was the natural conclusion of a corrected injustice. What I felt was something quieter, a sense that the record was now complete, that the sequence of events had been formally documented from the false report through the conviction, and that anyone who needed to understand what had happened could find it without relying on anyone's word, including mine. My mother and I did not discuss Marcus for several months after the settlement. When we did discuss him, it was briefly and practically. She told me he had moved out of her house and was living in another part of the state. I acknowledged that information and moved on to discussing her medication schedule. She never asked me to forgive him. I think she understood on some level that forgiveness and legal process occupy different territories, and that conflating them does damage to both. Or perhaps she simply did not know what to ask for and said nothing rather than say the wrong thing. Either way, the silence was appropriate. I received the reclassified police incident report from the records office 6 days after I had made the request. I filed it in the folder alongside everything else. The report listed my name as registered vehicle owner, noted the initial traffic stop, documented the evidence of ownership I had provided, and recorded the reclassification determination. There was no mention of stolen vehicle in connection with my name anywhere in the document. The incident was described as an unsubstantiated theft claim. That was the official record. I have thought many times since about what it means to be at gunpoint in front of your own car on a street you have driven for 11 years, because someone who shares your bloodline decided that a refusal to loan him something he was not entitled to warranted a call to the police. I have thought about the seconds between the loudspeaker instruction and my hands going through the window. The seconds in which I had to make the decision in real time to do everything correctly, to give no ambiguity to officers who had been told they were looking for a car thief. Those seconds are not in any legal document. They are not in the settlement agreement or the conviction record. They belong entirely to me, to the private experience of what it is to be innocent and accused simultaneously, and to have to navigate that space with complete precision while officers position themselves behind their vehicles. I carried those seconds for a long time. I still do, in some form, but I do not dwell in them the way I might have, because what followed those seconds was a demonstration of something I have come to believe completely. which is that a person who knows their own record, who has built their own record, who trusts their own record over other people's narratives about them, is not ultimately at the mercy of the people who try to define them from the outside. The record spoke. The systems, imperfect and slow as they are, responded to the record. The outcome was not perfect and the process was not painless. But the foundation it was built on was solid because it was factual, and facts presented in the right order to the right people at the right time have a weight that no amount of bad faith revision can fully overcome. There is something worth noting in how all of this concluded, because I think people often expect the end of a story like this to feel like a dramatic door slamming shut, a final confrontation, a courtroom moment where someone breaks down and confesses. That is not what happened. The ending was procedural, quiet. A series of documents filed, a settlement signed in a room with no audience, a conviction entered into a record that will exist for as long as such records are kept. The drama was in the beginning, the guns and the handcuffs and the hood of my car. The drama was in those 19 minutes in the back of a patrol car, not knowing exactly how bad this was going to get. The resolution was not dramatic at all. It was methodical, patient, and documented. I think that is actually how justice is supposed to work. Not as a spectacle, not as a reckoning engineered by emotion, but as a process that can be accessed by anyone willing to build the record, engage the system, and trust that documentation has more enduring weight than narrative. My car still sits in the same parking spot in front of my house, same dark blue four-door. 11 years of driving on Hartwell Road. I drive it every day. I have not thought about that traffic stop every time I drive it, but sometimes, at the particular curve in the road before the intersection where it happened, I notice the spot automatically, the way you notice any place where something significant once occurred, not with fear, not with anger, just with the quiet recognition that this is where something happened, and that it has a place in the record now. I have the folder, everything is still in it. I keep it in a filing cabinet in my home office. I do not think I will ever need to refer to it again, but it exists, it can be retrieved. It is organized and dated and complete. That matters to me more than I can fully articulate. Maybe you understand why. Maybe you have had your own version of a folder you had to build fast, in the hours after something happened that you did not cause and could not ignore. Maybe you have had your own 19 minutes in the back of a car, trying to organize what you knew against what someone else had said about you. If you have, I would be glad to know your thoughts on how it went. And if this kind of story is something you find value in, there is more where this came from. Stay close.